Mr. Leonard, before we start,
Yes.
have you and Mr. Peter spoken about timings? Are we all okay on timings?
Using a council-orientated time estimate, I'm hoping to wrap up in about 20 minutes or so.
All right.
And I've said it before, and I'll be wrong again.
Well, not too wrong, I hope.
No, indeed.
Will that be all right, Mr. Peter?
Yes, I'm afraid to say, but I think that I'll be dealing with the point of liability, and Malone Junior and Mr. Trotter will be dealing with sanction. We hope to wrap it up by Malone Friends asked for half an hour to reply. I hope we can give them that. It maybe a little less, I can't be quite sure.
Yes, thank you very much indeed, Mr. Peter. Well, I didn't think we're going to need half an hour to reply, but anyway.
I hope not, and
No.
I've agreed with my learned friend, Mr. Peter, I will deal with the reply rather than both our parts. That's please,
Right.
cool. Can I just take you then to, please, the judgment in relation to this, I hope not overly repetitiously, at core bundle 85, where you see set out at paragraphs 3, 4, 5 of that judgment, Miss Justice Butcher, 4th of October, and I remind the court of those paragraphs without belabouring them and reading them out, because they only go to underscore in my submission the point I make about the state of approach in terms of Miss Justice Butcher to the issue of service and the significance of it. But as I say, I'm not going to read it out, but that's where, as it were, he landed on the issue of service, and we say that is a significant starting point. We know that by the time the return date for the hearing had come about, there had been one appearance at which the appellants had been represented, and then the case was adjourned over for a full argument, as it were, as to further applications on the 20th of November. I'm going to take you straight to that, because that interim hearing doesn't add a huge amount, save as we know that there was an order for the appellants to serve some evidence in the interim, and the court's already touched on that in argument. The fact remains at the hearing on the 20th of November that no one, and I include the judge and my then judge and indeed my own friend Mr. Yates, who appeared for the appellant, and indeed those for the claimants, appreciated an issue about the service that we raise in this court today, and I don't want to shrink away from that. If you look at paragraph 19 on page 606 of the supplementary bundle, paragraph 19 at the bottom, where Mr. Yates sets out a position in relation to service. And so again, we have those parties to the hearing in our respectful submission proceeding on something of a false premise across the board, that the order that we have discussed that should have been obtained before lunch after CRS came off the record had not been obtained. Can I just invite the court now to look at the emails that are relied on in the context of service for the second appellant, and they start at page 622 of the supplementary bundle. And you'll remember that this is the email address which, as a method of service, survived the second service order of Mr. Justice Calver. And what you'll see in these documents, and every one of them, is that the email address to section includes the email address relevant to this point, majid@falloil.co.ae, and others. And each one of the following several pages, we can follow them through, but all contain the observation that we see under the subject line. Delivery to these recipients or groups is complete, but no delivery notification was sent by the destination server. Now, I don't believe, save for belief on the part of the claimants, that there is any direct evidence of what that actually means. In other words, we don't know whether it's complete in relation to being received at the server, complete in relation to being received by a computer which has downloaded an email from a server, or complete because it can be said that the email has been read by someone with access to that computer. And if my own friend can correct me about that, then I will stand corrected. But I don't believe there's any evidence assisting the court with what that actually means as a message. You'll see if you just pass through the pages that follow. And these are emails sent throughout the course of 2023. The first one that I've just drawn your attention to being, I think, just before CRS came off record, but the remainder, and they pass through all the way until your page 636 in exactly the same way, in relation to exactly the same addresses. And I think if one married them up to the chronology of various documents that we've seen being served during the course of this, we would see an email that probably contained the order of the 12th of May relating to the change of date from December forward to October, and indeed further on in this collection in September, when Mr. Richards of Jones Day tells us in Richards 5 that he sent the further correction to the same email address. And so again, without belaboring, this is the email address that they were entitled to use for service in relation to the underlying proceedings. No separate order in relation to contempt proceedings, but my respectful submission is that one needs to look at these with the greatest possible circumspection, bearing in mind how important their significance came to be in the context of the contempt. And the same point I join with in relation to my own friend for the first appellant, to say that, in her case, series of text messages, in our case, series of emails, would have been enough to satisfy a judge that that email address alone was appropriate for alternative service in the context of contempt proceedings. It is in our submission overreaching that possibility by some considerable measure. The next point I want to engage with specifically is this question of knowledge, which I know the court is interested in, absent the issue of service. And I want to, if I may, help you specifically with relevant paragraphs in the judgment of Mr. Justice Butcher, which you have in the court under 100 onwards. But I know that the paragraphs of particular interest start at 26. This first paragraph deals with email traffic, and it's the emails I've just invited the court to that it is relevant. And the it leads on from the paragraph before. As to his statement, he was thereafter completely in the dark, and that is, of course, Majid al-Sari. I am sure that if he was, which I very much doubt, it was self-imposed darkness. Then he says this: the same applies in relation to the period after CRS came off the record. There's no lack of knowledge in that regard. Numerous communications, the one we've just looked at, were sent by Jones Day to an email address which had been ordered as effective alternative service. He appreciates that point plainly. And then this: there was no indication that emails to that address were not received. Now, I know this court is weary of counsel picking over the minutiae of words used by a judge in relation to a particular point, and it can sound unattractive and isn't always appropriate. But there is a sense, is there not, in which that is looking through the wrong end of the telescope. And that in the context of service, the question really is, can I be satisfied that those emails have been received by the second appellant? Not, is there any indication that they haven't? Particularly, as I said a few moments ago, the wording on the emails that we've looked at that have been produced by the claimants do have a piece of rubric on them that is not only open to one interpretation. There are more. He goes on, a series of notifications say that the delivery to the recipients or groups is complete. That's the ones we just looked at. They were unable to send or bounce back messages. Magid 3 does not say emails were not received at that address, nor does it say the address was inoperative. Indeed, it's very thin on detail. And I have to embrace that observation by the judge. That specifically is not addressed in Magid 3, the affidavit which was filed shortly before that hearing. However, from an inference point of view, again, I respectfully suggest the starting point is, has it been established to the satisfaction of the judge considering this issue that service was effective through these emails? In my respectful submission, the rubric on them in combination with the denial that he knew anything about the hearing is certainly persuasive enough to allow reasonable doubt to creep in. Can I look now at paragraph 27?
Paragraph
27, the very next one. I think all of these, I'm intending to deal with all the paragraphs that address the issue of knowledge, knowing as we do that my primary submission is that acceptance of service had fed very significantly into this.
We've got that. Let's just get to the paragraph.
Yes, of course. 27. Jurisdiction challenge said to be defendant's own application listed. They must have been aware for that. Again, I can't gainsay precisely the dates of those, but I do respectfully suggest that saying that they must have been aware of it and therefore ignored it, perhaps ignores the fact that it was listed a long time previously, and perhaps ignores the fact that they would still need to be aware of it for the purposes of attending. But again, that is, in my respectful submission, speculative rather than probative as a piece of analysis. Likewise, 28 deals with the text messages that you've already been addressed on. Again, and if I might say so, 29, this issue of communication between two defendants and now appellants, and that there is, they've instructed the same solicitors. In my respectful submission, amounts not much more than to speculation rather than a concrete basis for so finding. And finally, in relation to the point about acuity law, which I made just before lunch, paragraph 30, as you'll see, that attaches to Abdullah. And of course, if you're going to draw an inference from that engagement, you'd have to infer that acuity law told Abdullah, and that Abdullah then passed that on to the second appellant. And again, with respect, in my submission, that is a matter of speculation rather than inference. May I then, with those submissions in mind, move on to the issue of set-aside? Now, there's a difference of emphasis between my own friend Miss Pugh and I on this. Had one been aware, turning up, as it were, in front of Mr. Justice Butcher for the hearing on either the one after the 4th of October or on the 20th of November, that an ErdNet mining application for alternative service in the context of those proceedings had not been made, there is a sense in which the starting point would have been an analysis along the lines of the Clear Springs Authority that my learned friend invited you to. Namely, this is a position that has been reached without proper service, and therefore, if one looks at paragraphs 50 of that authority in the bundle, I needn't take you to it, the issue is prejudice, which in that case, Sir Anthony Clark, MR as he then was, identified a money judgment as being sufficient, let alone a sentence of imprisonment that happened here. And so that would have been probably the starting point. But if the judge was satisfied that service had been complete, then you'd move on, wouldn't you, to the set-aside, because set-aside presumes that service has been properly made. Now, I'm not going to repeat the submissions made by Malone from Ms. Pugh in relation to that. She's dealt with all of those respective considerations in relation to timing, good explanation for not being there. Of course, I've already addressed you on this issue of service feeding into those, and I won't make that point again. As far as the issues and for triability, if you like, are concerned, or arguable cases concerned, I'm not quite sure what happened in relation to two of them, because in relation to the management stroke ownership of companies point that was taken by Majid in Majid 2, and in relation to the attachment order point, also taken in Majid 2, Malone and Friends' positions that those were abandoned by Mr. Yates by implication of paragraph 40 of his skeleton argument that was produced, and only referred to impossibility as a reason for non-compliance and therefore a potential defence. However, the UAE point was still very much front and centre in terms of the appellant's vulnerability in that regard. So I have to say, for my own part, I wasn't there, not entirely clear to me what was abandoned, what wasn't abandoned, and what might be maintained. But what I hope I can say properly at this stage is that those are issues that the appellants now are entitled to have tried by reference to evidence having properly been served with a notice of the hearing. And beyond that, for the purposes of this argument at this stage, I don't propose to take the court unless I'm asked specifically about those issues. Finally, if I lose on everything else, sanction. All I will say about sanction, Milady, if I may, is this. On any view, if the judge was approaching it correctly, this is a bad case. There we are, a year on after the original service of the disclosure order. And if the judge is right, we still have persistent failure to deal with it. And against that background, it's quite difficult to say that he shouldn't have viewed it as a serious case and addressed it accordingly, save for the point about Mohammed that Malone and Friend made. And it's not obvious necessarily to see why a distinction should have been made in relation to all three of them, because on one view it punishes somebody who has at least taken some part of the proceedings to a greater extent than someone who's ignored them literally completely. Whether that's the right approach, and again I've set out that argument as an argument, matter for the court to consider. Suffice it to say that any issue about who might have disclosed what between the two appellants and when in relation to what companies are matters that, should this matter ever be tried, as it were, at first instance, that, for that to be sorted out at that stage. And I don't propose to take the court further on those issues today, unless there's anything else I can assist you with.
Thank you very much indeed, Mr. Lemon. Mr. Peter.
Milady, in this action, the claimant claims to enforce a Sharjah judgment dated 2016, which now is in excess of $100 million interest. And defendants have spent years evading its enforcement in a number of jurisdictions. In February of 2022, claimants commenced this action in England for enforcement of that judgment as a death in common law. That summary judgment has been given now on this claim, the defendants having breached an unless order in relation to the giving of defence evidence. On the 18th of February, Mrs. Justice Cockle granted a worldwide freezing order against the defendants, which contained a number of asset and document disclosure obligations, together with orders for service out of the jurisdiction and alternative service. Now, there's no dispute that this order was properly served on these appellants, at latest by the 23rd of February. Then, as Mr. Justice Calver found on the return date, they had taken steps to avoid being served. Reference for that's supplemental bundle divider 8, page 80. As he found, they or their agents hung up phones. They refused to take deliveries. They refused to authorise read receipts. The first appellant, when telephoned on the number ending in 488, which we're concerned with, he answered that phone, and he said that he interrupted the claimant's solicitors who were explaining the order with the script, saying that he knew what they were going to say, and he didn't want to hear it. And he said, "Talk to my legal representative." When she asked him to name the legal representative, he then refused to name them. And then, worst of all, a lawyer at the lawyer's offices intimidated my solicitor's representative by sending voicemails and texts, which are in evidence, threatening to falsely accuse him of placing drugs in the boxes containing the documents and saying that they would call the police on him. And given the penalties for drug abuse in that jurisdiction, that's a very serious threat indeed. So the order required the defendants to do the following by the following deadlines as set out by Mrs. Justice Cockerell. They're referred to in the schedule to the contempt order, which for relationship's reference at the core bundle 81. The 24th of February was a deadline for informing of assets over £50,000 and informing also of all their bank accounts and also of all companies over which they had control. On the 25th of February, they were supposed to inform the claimants of the location of any asset documents as defined, namely being documents that evidenced the nature and the value of assets. 2nd of March was the deadline to inform the claimants of asset disposals as an undervalue, a very important part of the order, which would have required them to disclose assets that transferred in undervalue or to connected people from 2015 onwards, and what had become of those assets too. And also to give the names and contact details of all third parties or banks holding bank statements or asset documents. And by the 4th of March, the last deadline, that was for affidavits confirming what assets they had, what bank accounts they had, and also to confirm the location of the asset documents and of the third parties holding them. Now, I've gone through those deadlines in some detail because Mrs. Justice Cockerell made a very detailed order, given the severity of the background of the case, but the defendants failed to meet any of those deadlines. And they still hadn't on the 11th of March when the matter came on a return date before Mr. Justice Calvert. He was forthright in his comments, saying the defendants had shown a seriously contemptuous attitude, exhibited fairly extraordinary conduct, and that there was no apology, and that they'd made no suggestion they would comply. So for those reasons, he refused an adjournment. There's a reference at the supplemental bundle at tab 10-103 for a quotation of Mr. Justice Calvert. So there's no doubt that they were told they were in contempt of the judge at that time. He made a further order, ordering them to send signed instructions to third parties holding asset documents, or in the case of banks, bank statements, and to deliver copies of those letters of authorization to claimant solicitors by the 22nd of March. That was supposed to be designed to get bank statements from all the banks. But despite these severe judicial comments, the defendants failed to obey that order as well. Then on the 16th of March, the second defendant served an affidavit on behalf of himself and his father, it's from both of them, purporting to explain the non-compliance, but actually contemptuously, not promising to comply, but expressing the view that the judge had been unfair in making the order. So it was a contemptuous affidavit. A reference there to the judgment there, it's a core bundle, pages 89 to 90. Nothing more then for nearly a month. But then 4 weeks later, on the 14th of April, they still hadn't complied with any of these obligations. But on that date, their solicitors, CRS, wrote on behalf of the defendants, saying that now they did wish to comply with disclosure and promising they would do so by the 28th of April. Now, that was a less than frank promise, as the Laing judge later found, because in the meantime, they'd secretly applied to a court in Sharjah for an order relieving them of responsibility or making sure that such an order would be unenforceable. That was an unsuccessful application. The reference there is at CJ, that's core bundle 90. So the 28th of April came and went without any disclosures. So on the 12th of May, after some 11 weeks of failure to comply with what Mrs. Justice Cockerell and Mr. Justice Calvert had ordered, the claimants issued and served this committal application on the defendants. And there's no dispute this was served properly in accordance with CPR 81. It was served on CRS solicitors in accordance with the new rules allowing that, and there was no disavowal by the solicitors of that service. That was proper service. Then on the 13th of May, the applicants served another affidavit purporting to give some compliance, but in fact mostly just giving invalid excuses for not complying. They claimed, and I say they because again it was an affidavit served on behalf of them both, they claimed that UAE law forbade them about giving information about the assets of companies they controlled. But as Mr. Justice Butcher later found, that was no excuse, because, and I'll take your ladyship to the authority later, because if there's a plea made that a foreign law we might put you under a penalty for making a disclosure in England in pursuant to a judge's order in England, that's a reason to ask a judge in its discretion to vary the order, but it's not an excuse for non-compliance. And that's the Servie case I'll come to later. So Mr. Buster's Butcher found that was an irrelevant averment, so to speak. But this excuse in any event, as Mr. Justice Butcher later found, didn't apply to their own assets, because of course that plea wouldn't apply to personal assets anyway. And he found, on evidence before him, they had assets which they hadn't disclosed, because he found that they had interests in companies and bank accounts, and also in a yacht, which they hadn't disclosed. And the reference for that is to the core bond minutes, page 91 in his judgment. They claimed they had no relevant interest in the companies, but then, as Mr. Justice Butcher later found, the evidence showed, documentary evidence, that they had such interests as shown by registered trade licenses. Reference to that is of the supplemental bundle, tab 21, page 252 and 268. And they also admitted being managers of the companies, so therefore with knowledge of their assets. And reference there again to the supplemental bundle at tab 11, pages 116, 119 and 121. So they claimed they didn't, also finally they claimed they didn't have to disclose Dubai assets, which was subject to attachment orders, because they said that rendered the assets valueless and below the £50,000 threshold. As to that, that's incorrect for two reasons. I mean, first of all, as Mr. Justice Butcher correctly found, and there's authority I'll take your ladyship to later, which says that you don't look at the incumbent, you look at the market value, not the unencumbered value of an asset for the purpose of disclosing assets under a freezing order. Also, the order of Mrs. Justice Cockrell made it clear that attached assets had to be disclosed. It actually says so in terms, and there's a reference that I can take your ladyship to. Maybe I should do that now. That's it's in the supplemental bundle at divider 2, which is where one finds Mr. Justice Cockrell's order. And if one looks at page 23 in the bundle, at paragraph 10.1a of the order itself, just under the title Information, Provision of Information as to Assets. And there one sees in the last words, disclosure of assets above 50,000, whether in his own name or not, etc. And if applicable, which of those assets is an attached asset? An attached asset is defined a little earlier in paragraph 8, which says that paragraph, which is the page before, on page 22, paragraph 5 above, which is the freezing provision, doesn't apply to an asset which is subject to an attachment order or similar order in the nature of attachment in the UAE, provided that the respondent provides the details of that attached asset in accordance with the provision below. So although such an asset may not be frozen by this court because that might cut across a similar order that might be made in the UAE, it doesn't let them off having to disclose it. So that evasion also was without merit. And there's never been any attempt whatever to disclose at the documents, asset documents, or saying where they are, or identifying their custodians, or writing letters to the banks for bank statements. And there's been no affidavit stating whether or not there's been transactions in undervalue. There's never been any attempt to do that. So it's now 2 years on. That still remains the case. Rather extraordinarily, one might adopt that adjective used by Mr. Justice Calver. This remains the case before this court too, even after findings below that these are contempts. There still is no attempt to purge. There is no promise from a learned friends on instructions to do so either. So that was the position anyway on the 13th of May. Now, over the rest of that year of 2022, the appellants expressed through their solicitors a desire to put in evidence in opposition to the committal, including Part 35 expert evidence on the UAE law, again to go to this point about penalties they might face if they disclose company assets. Well, they applied for and they got permission for that expert from the court. Under the rules, they should have put in their evidence by the 10th of June because it was a heavy application. But then throughout the rest of the year, they applied for, or they asked for and obtained 6 extensions of time for the service of their evidence in opposition to the committal proceedings. That's over 8 months. But they never served any. In their penultimate application, was made on the 13th of December 2022, that being the deadline for the, as it then existed. They asked for a further 7 days final application for an extension to the 20th of December, saying that their evidence was in an advanced stage. Then, on the 20th of December, that deadline, they made an ex parte application for a further extension, suddenly asking for an extension that would be 7 to 9 months, which was that the rationale for that being it would come after the jurisdiction challenge, which was listed for the 13th of June. They said that they needed time to respond and that they might use that evidence to satisfy the balance of their disclosure obligations. Now it was that application which resulted in the order Mr. Justice Fox and the ladyship saw this morning. He recorded that their record of compliance with orders was poor, but he gave them until the 24th of March to put in their evidence. And the reference to that is it's now skeleton paragraphs 21 to 22, and also it's referred to in the core bundle at pages 143 to 144. They never did put in any further evidence or further compliance. And apart from Majid 3, still haven't. They also defaulted on orders for submitting evidence on the parallel summary judgment application. On the 23rd of February, their solicitors came off the record because of a dispute with the defendants, disputes over terms of the retainer and also complaints that they hadn't paid fees. And thereafter, the defendants, these appellants, stopped engaging with any part of these proceedings since then. They didn't give any address for service, contrary to CPR 6.211 and 6.24 and Practice Direction 42, paragraph 5.1. They didn't give an address for service, which, since they were at that stage still under the jurisdiction, they should have done, nor have they ever given an explanation for failing to do so. They knew there was a summary judgment application pending for the 4th of October. That's a significant date because on their story, what they still might have known about was the 4th of October being a date when there would be a hearing. Although the hearing then was used as a slot for the committal, nonetheless, they didn't turn up or make any inquiries about a hearing which on their story they ought to have known about. They knew there was a jurisdiction hearing fixed for the 13th and 14th of June 2023, and they knew that there was this committal hearing outstanding. So they knew that all these hearings would progress. But the point is they made no attempt to contact the solicitors of the claimants or the court. They just disengaged. And the solicitors did tell us, though, that the email that we used for serving the change of dates on the second appellant was the email that was the last known one to CRS themselves, because they'd been using it for contacting the second appellant. And there's a reference there to that, is at the supplemental bundle. It's divided 35, pages 540 to 541. Maybe I'll take your ladyship just that. As I said, it's divided 35. And that's at page 540, 541. And as you will see there, this is a certificate of service where if one looks halfway down the page on the right, this is to do with the order for coming off the record. In bolded it says, give the address where service effected. And so says for the claimants, that's one address, but the second line, it says for the first, second, fourth and fifth defendants, majid@falloil.co.ae, that being the address, which is the address in question in this case. If one looks across the page, at the top of page 541, the second paragraph in that box on the right, second little paragraph says, as regards the first, second, fourth and fifth defendants, the last and email address of the second defendant and them. So it's a reference to the email which is there on the left. So this was the email which was being used by the solicitors to putting that then to one side because they didn't turn up then for the CMC on the 16th of February. They didn't file any further evidence on the deadline given to them by Mr. Justice Fox, which was for the 24th of March or at all. And they didn't turn up for the jurisdiction hearing on the 13th and 14th of June, even though it was their application. Other co-defendants did, but they didn't. But this didn't stop them indirectly or directly litigating against, or threatening litigation against the claimants by other means. On the 11th of April 2023, their co-defendant, Globe, brought an action against the claimants in the DIFC to restrain the claimants from dealing with the bridge properties, which were the properties which they were occupying. Now, the timing of that action was described as striking by Mr. Justice Bright in those jurisdiction hearings, the implication being that the Saris are behind it. Now, I can't prove that at this stage, but the defendants also instructed Acuity, new solicitors in England, as my Lord Justice Mills pointed out. They were instructed to bring injunction proceedings against the claimants in relation to the preservation of documents that might be found at the bridge properties in London.
Now, you said the defendants instructed Acuity. Can you be precise? Because I think Mr. Leonard said it was only
Abdullah.
the first Abdullah.
I better check that. Yes, maybe that's the case.
Just Abdullah.
Yeah, Abdullah is right. That was just Abdullah. Yes, that's right.
Thank you very much.
And so, in the light of this disengagement and failure to file evidence and the breach of unless orders in the summary judgment proceedings, Mr. Justice Butcher directed the committal to be brought forward from the, I think, 2-day hearing which had been listed in December to the slot that was originally put aside for the summary judgment hearing of the 4th of October. And he made an order to that effect which misidentified the date as being the 3rd, and then another order came in correcting it to the 4th, as we know. Now, those orders were served, as your ladyship knows, by text to the mobile phone, the 44881 or 88441 of Abdullah, and to the email address of Majid. And as is accepted, both of these addresses were the subject of alternative service orders by Mr. Justice Cochran, Mrs. Justice Cochran and Mr. Justice Calver. Now, these orders had not been challenged over during the course of the proceedings. There had been no objection to them for all the time that CRS were on the record. And also, it's important to bear in mind that the defendants knew that these were the contact details which were still pertained, would be a channel of communication which should be approved by the court. And so this mobile number, though, was also given as a contact number for both Abdullah and for Majid as their contact number in the Sharjah proceedings, the one where they unsuccessfully attempted to get an order disenforcing, so to speak, the freezing order. Now, the reference to that's at supplemental bundle, tab 21, at page 57. If I can take the leadership to that. It's tab 21.
87.
Is it? Oh, sorry.
No, I didn't hear what you said.
Oh, sorry. 50. Let me just check it. Actually, I'm using the wrong number anyway. It's supplemental bundle, page number is 239. Apologies. It's page 239 indeed. So there one sees that before the Sharjah Federal Court, the claimants being a petition with a certain number for the year 2022, Abdullah and Majid are the claimants, and the address, they give their own address there, and the mobile contact is there just on the left by mobile, which is so both of them are holding themselves out as being contactable at that mobile number. So all the orders about the date were received by Abdullah's phone. Now the records, the electronic records show, because they're blue and because there's no exclamation marks next to them, that they were actually received onto that phone. Because of the way in which the records of read receipts get deleted message by message by message in the way they're stored, so we can only see the last message and the result there. We know that they were physically present upon Abdullah's phone. Also, I would say Majid's phone, in the sense that both of them have associated themselves with that mobile, certainly for charge purposes, as being their contact place. We draw the inference which Mr. Justice Butcher accepted, that those were available and would have been read. The last one we know was on the 10th of October, which indicates it's being monitored. So that's evidence in itself that that is the case. And there's a whole line of them. I don't think I need to show them to your lordship or your ladyships again, since you saw one page, although I can take you there if you like. But what you will see page after page is the message, including the message saying the date is now the 4th of October for the committal hearing, and enclosing the documents, the notices of motions and the evidence. And there's everything else going on in the proceedings also, which is there recorded as being on that phone. Now, importantly, there isn't a distinct denial that they were received on the phone. You won't find that in the evidence or in the skeletons. You won't find a denial that they were received. They say they didn't know about the proceedings. Doesn't mean that they're denying having got them. They don't deny that. The emails sent to Majid's address, there's some more electronic records. I think Malone Finn took you to a typical email which there said, this email has been, the precise words were received by the recipient. The delivery to the recipient is complete. Now, my submission, that means what it says. And there is a presumption, of course, in law and evidence that a document, in fact, a record means what it seems to mean, as it said otherwise. It's quite clear here. That it's therefore appeared in the recipient's email bank. And again, critically, and this is also noted by Mr. Justice Butcher, there is no denial from Majid, either in Majid 3 or through counsel, that those emails are present and were present upon his email address. A very easy thing to deny, but it's not denied. So that in itself, those two things in themselves, are evidence from which the learned judge could and did draw the inference that they knew what was going on. If one looks at the background, one looks at the lack of specific denial, and there can be no doubt at all that had a denial, oh, that was never on my email, no, that was never on my text, where there's the instructions being given, then your lordship would have, your ladyship would have heard about it, but we haven't.
Ms. Peter, what do you say about Mr. Leonard's point about the timing of the evidence? So that Majid 3, I think, came before the evidence about all the messages.
I mean, first of all, the evidence that there's a much earlier affidavit, let me just get the reference, where in support of the application for committal, in our evidence for the 4th of October, we do give evidence of service which says that this was sent to, that these documents were sent to the email address and also were sent to the mobile phone. So that's evidence which was in September.
Right.
And I'll get the reference in just a moment. And so that means they would have had that evidence, if what they say is true, on the 10th of October. So they knew that that was an issue about service then. So when Majid was sworn, he knew there was the issue about the email and the issue about the text, because that was already in the evidence. When the skeleton was put in, that was 5 days. We then responded to that. And that was where we actually put in the copies that were shown to your leadership today. And that, I think, was put in on the 15th.
13th, Richard.
13th.
No, 15th.
That was put in on the 15th of November. So that was 5 days before the actual hearing of the 20th. So there's plenty of notice about these addresses being critical anyway. The documents themselves, they had 5 days before the set-aside hearing.
Yeah.
But this is the critical thing. They could easily have said, but this is the first time we've seen them. They haven't. They still haven't. So then, so Mr. Justice Butcher then gives his judgment, first of all, no one turns up. And he directed himself, we say correctly, in accordance with the Erdonet considerations. There's no complaint really made about that other than the idea that they should be applied without too much rigour given what's at stake. I don't disagree with that. He went through all the factors carefully, and no one's saying he misdirected himself about the factors about going ahead without someone being present, given the background. He went through the evidence. He found that none of the deadlines for disclosure had been met, so that was a contempt of time. He agreed with Mr. Justice Calver this was a serious contempt. He found the delay was deliberate. He found all the other contempts were made out. Those findings are summarised in our skeleton, paragraph 27, which is at Call 14146. So he had evidence there was basically quite a simple case to prove in this sense. They were ordered to do things and they simply hadn't done them. So it wasn't a question of having to prove a positive act like a molestation order or something. These were straightforward. And the defences which might have been available, as put forward in Majid 2, he correctly dismissed. So he adjourned sentencing until the 27th of October. And then it was then that on the 20th of October that Jane's solicitors wrote saying they'd been approached by the applicants' Dubai lawyers. On the 24th, they confirmed they were instructed to ask for an adjournment. But there was still no apology and there was still no offer to purge. So on the 27th of October, Mr. Justice Butcher adjourned sanctions until the 20th of November. There was no application to set aside at that stage. Mr. Justice Butcher, though, did order that if they wanted to say that they didn't know about the 4th of October hearing, they would have to put that on affidavit. And that was where Majid 3 came from. So it was on the 10th of November that Majid 3 was served, claiming they'd only found out about the date on the 10th of October on documents being delivered to his house. No mention, by the way, of the effect of the red receipt, which also would have showed that they would have been aware of it from Abdullah's mobile phone as well by that stage. Now, that affidavit was extraordinary in that it contained at least 2 demonstrable falsehoods and others as well, which must have been deliberate. In fact, one might say they're so obvious that they almost could be described as being contemptuous of the court, not just in the technical legal sense, but actually in its everyday meaning, contemptuous. They actually denied, I say they because it was sworn by Majid on his own behalf and Abdullah's, they actually denied knowing that committal proceedings had been commenced at all. And secondly, the other lie of knowing that the jurisdiction hearing had been listed for the 13th of June at all. So the former is an extraordinary lie. I mean, given the fact it had solicitors on the record for over 8 months, asking for 6 extensions of time, asking for expert evidence to be put in. And inconceivable that the solicitors wouldn't have told them about all that or done all that without taking instructions, and of course not. And also must have been charging for it, no doubt. I mean, inconceivable. No evidence, of course, from the solicitors, or have not been witness summonses here to say, we're awfully sorry, but we somehow forgot to tell our client about committal proceedings for 8 months, nothing like that. As regards the jurisdiction hearing, that had been fixed in August of 2022. So it's these matters are referred to in the supplemental bundle divided 32, pages 435 to 6, paragraph 8 to 10. I might just, that's some of the evidence. I might just take relationship to two instances of the correspondence there. This page, in the supplemental bundle, page 578. Page 578, which is behind divider 35. We see here, this is the, it's from Mr. Tame listing a commercial court, fixing the jurisdiction hearing for the 12th and 13th of June. And if one then looks, page 581, looks at page 581, one sees a letter there from CRS to my solicitors, paragraph 2.5. The reference there to it, the clerk's to your counsel team are liaising with the clerk's CRS counsel teams to find mutually available date, and the jurisdiction challenges which are now listed for the 13th to 14th of June. So that's only one example, but it's absolutely clear, therefore, that the solicitors knew about this fixing, and therefore inconceivable that they didn't. So we say that's simply a direct lie. As regards the and an example of correspondence relating to the contempt. Sorry, this is... Yes, so if one looks at page 475, for example. One sees in the third paragraph there, a letter from CRS to our side. In the committal application form, the claimants specifically alleged breaches of various parts of the WFO and so forth. As you are aware from Magic 2, in the opinion, CRS defendants say that they have defences to the allegations of breach. So that must be on instructions. And then at the top of page 476, there's a representation that the appellants would be at disadvantage if obliged to file the evidence and answers to the committal application without any responses, and further references, 4 paragraphs up from the bottom, about the order in which the application should be heard. There's no question of a delay in the appellant's evidence and answer to the committal application having any effect. We'll look at the next letter on page 477 on the other side of the page. There's a heading there, time for the CRS defence evidence in opposition to the committal application. This is all in July. I won't weary the court with any further examples, but that means it is simply a straightforward lie. It's a simple, straightforward lie. He says we didn't know about the committal proceedings. It's a straightforward lie. We didn't know there was going to be a hearing on the jurisdiction application. He suggested that it maybe wasn't fair to say that these were lies, this entirely discredits Majid's and Abdallah's evidence. But the truth is that Majid 2 contains the only evidence that we have from them that they were unaware of the 4th of October hearing. But they don't condescend to detail in that, as Mr.
Sorry, Majid 2 or Majid 3?
I'm sorry, I meant 93. Yes, beg your pardon. But as Mr. Justice Butcher says, they don't condescend to detail in that affidavit. There's a blanket denial, not just about the 4th of October hearing, but no, we know nothing about any committal at all. My goodness me. We knew it was intimated, but we didn't know anything about any kind of committal at all, nor jurisdiction hearings, and we had no access to any correspondence at all no contact at all with our solicitors after December, even though they acted this for 2 months. So encompassed in that general defence is, of course, they wouldn't have known about the 4th of October hearing. But that is a generalised lie, which can simply be rejected. Mr. Justice Butcher was entitled to reject it, and indeed, who wouldn't? So once one rejects that, where are they left on a denial they didn't know about the 4th of October? It's a bit like being charged with murder when someone's actually in a particular room and you're said to be in the room. You say, I wasn't in that room at all. I was in Shropshire. Then it's found actually, well, you were in the room. Well, that means that you've got a slight problem having some explanation about self-defence. A bad analogy, maybe. But here, in any event, it means once one rejects this story, Magic 2 is binned, there is nothing left apart from all the evidence that shows.
Magic 3 is binned.
I'm sorry, Magic 3. I beg your pardon again.
It's all right.
I'm getting tired. Magic 3. Then there isn't anything really against the electronic evidence which shows delivery, and the whole background, which shows a tissue simple of evasion and dishonesty and contemptuous behaviour, which means that the learned judge was perfectly entitled to find that they actually knew, which was his finding. He judged at first instance, assessing all the evidence, being aware of the background in more detail than I've been summarising for this court, came to that conclusion that they knew, which was per excellence an example in my submission of where the first instance in trial there's plenty of evidence upon which to base that conclusion, and not one which this court would normally interfere with in the absence of something going wrong with something not being taken into account, an error of law. No such is identified here. So, on the 17th of November, that's 37 days after the defendants first claimed to have found out about the committal, their then counsel served the skeleton argument, which was effectively applying to set aside Mr. Justice Butcher's finding under CPR 39.5, and with the tests there. We didn't take any technical point about the application not having been sealed and served in the usual way. And so battle was joined on that. And in the skeleton setting out the set-aside application, that was it, the supplemental bundle, it's tab 37, page 606. It was submitted, the application was prompt, that the defendants weren't aware of the hearing, and that was a good enough reason for them not to have attended. But as Benoni Defence have conceded, it was nowhere suggested that the method of service by alternative service was legally wrong. In fact, on the contrary, it was actually conceded by the predecessors that service was actually permitted and available. And there one sees that at the supplemental bundle at tab 37, at page 607. It's paragraphs 20 to 22 at the top, where one friend there in his skeleton said, under the service order of Mr. Justice Calver, 5 additional service methods, including D1, D2's home addresses, were permitted for LCs to serve in these proceedings, which that included the means at which we're concerned with today. So that was conceded they were permitted. And in paragraph 22, we chose to serve notice through only one of the 6 methods available to us. So it wasn't just a question of the point not being noticed, it wasn't, but it's more a question really of there being a concession that this was a method of service available. Now that, you'll hardly really criticise the learned judge for not having divined there was something else.
What about that second sentence? They also selected the one method they knew had a history of being non-responsive. Para 22.
Yes. I'm not sure which one that means. Let's check. Sorry. It's
It'll be the email address allowed for service in relation to these proceedings,
right.
which is the material one that we've all been talking
Right,
about.
that's what it is.
The two
talking
sentences
about
must
the-
be talking about the same thing.
Yeah.
So if that's the email address that is the one in issue here, that's the email address that CRS said they used to contact their clients on. So, I mean, it may not have been responsive to us if they'd been dealing with solicitors.
I thought they'd chosen two methods, one for Abdullah and one for Majid, the 4488 or whatever it is,
For Abdullah.
telephone for Abdullah, and the email for Majid. So this just seems,
Yeah.
unless it means one each, but
No, I think
otherwise it's inaccurate, isn't it?
I think it's talking about magic.
I think it's designed to talk about Majid's email. It may be badly put, but that seems to be what it's meant.
Right.
But if that's the case, it's a bad point anyway, because, as we know from CRS, that was the email address that CRS used to communicate with their own clients. So this goes nowhere. So the only defence that was raised in their skeleton, this skeleton, was that compliance was impossible because the time limits for giving disclosure were too short. And the Sector Guard case was cited. That, of course, was a case of real physical impossibility where there'd been an order to disclose what customers, I think, had been contacted using a particular list, and the list had been destroyed. So actually, it was an undertaking, not an order. That couldn't actually be complied with, as it were, physically. But here, as Mr. Justice Butcher found, well, he disagreed with that anyway. But of course, the remedy would have been to have applied for a variation and extension, which wasn't applied for. And in any event, even if you do breach an order for disclosure by not giving disclosure by Monday, of course, what you do is you hasten to remedy it and purge your contempt by Tuesday. And of course, this hasn't happened in 2 years. So it's another point that goes nowhere. Mr. Justice Butcher correctly directed himself about the three-stage test for setting aside the judgment. There has to be a good reason for non-attendance. He found that there wasn't because they found on the evidence they lied all about the committal proceedings and their knowledge of it, and that he found that they did know about the date. He found they hadn't been prompt because they didn't actually make the application to set aside until 1 working day before the hearing, and that was 37 days after they said they found out about it, which again was a matter which is again par excellence something for the judgment and discretion of judge below. And he also found that that there was no arguable defence could be raised, in fact, to the main points about the on the merits, and they have to tick all 3 boxes in order to be able to get a judgment set aside. So, and on the merits, well, on the question of no good reason, there's plenty of evidence to support that, which is his judgment at the core bundle at divided 10, pages 107 to 112, where he sets out all the evidence. I don't think I need to take your leadership to it. It's evasion in the previous proceedings, evasion of service found by Mr. Justice Calder, the lies in Magic 3, lies about not having contact with his solicitors, and the fact that he hadn't denied, the Magic hadn't denied receiving the emails had been received, and there was also the inference about acuity law. Of course, that was Abdullah, which, as Your Lordship pointed out, we told acuity about the committal proceedings. They were acting for Abdullah at the time, and then they came back to say that they had no instructions to deal with freezing order proceedings. But the implication being that it seems inconceivable a solicitor has an obligation to tell their client any matter that comes to their notice, whether or not it's part of their retainer, which may affect their interests. That's just a general obligation of solicitors. And this is not a difficult one. And my goodness me, they've got the committal hearing coming out against you. The idea they wouldn't have told them seems incredible. But if that was the case, one would expect to have a hard evidence about it rather than their friends seeking to draw inferences about whether they might have done or hadn't done. We don't have a clear story about that. The judge also found that even if Majid hadn't known about the date, that he had deliberately contrived that. They knew that the committal was coming. They knew there would be a hearing sooner or later. And the only judge found it's not a good reason for non-attendance if a defendant doesn't keep himself informed. And here, they hadn't given an address for service. They could easily have picked up a telephone and found out either from my solicitors or from the court what was going on. They kept themselves away. And in the estate acquisition case, that's authority for saying that where you keep yourself out of the way, you can't complain if you don't know about a development in the proceedings. That's when you know about the proceedings generally, not when you haven't been served at all. That's at tab 5 of the authorities bundle, lady. That's page 48. And sees that there, page 48, paragraphs 21 to 22. My judgment, if the reason for a party's non-attendance is he didn't know the hearing was taking place on the day it did take place, it would usually be necessary to ask why he wasn't aware it was taking place on that place. The mere assertion the party was unaware of the hearing dates, unlikely to constitute a good reason, it would usually be relevant to inquire whether the party was aware that proceedings had been issued and served. In this case, yes. Once a party is aware that proceedings have been served, he knows it's likely steps will be taken in the proceedings, and there will be a hearing or hearings. Unless he's nominated a solicitor to act on his behalf, he must be taken to expect to receive communications personally from the opposing party and or the court. This will include notifications of hearing dates. If he does not have a system in place for ensuring that such communications are received by him, he is unlikely to be able to rely on the absence of such a system to say he had a good reason for not attending the hearing. And so that is, it's on page 48.
Yeah, got it now.
And so, ditto paragraph 22, last sentence, it would be particularly difficult for a party to argue he had a good reason for not attending if the court concludes he deliberately avoided receiving such communications in order to frustrate the litigation process. And Mrs. Justice Butcher found there had been deliberate evasion. He deliberately kept himself in the dark. And in my submission, he had plenty of evidence upon which to make that finding, and one can't interfere with that finding. And indeed, aside from the fact that they clearly did know on the evidence, that's precisely what they did. You did quarrel with your solicitors, you don't have any more. You don't get engaged. You know there's a summary judgment out against you, you know there's committal against you, you know there's a jurisdiction application you've made. You know they're going on. You don't give an address for service like you should. You don't make any attempt to communicate. You know that they've got alternative service routes, but you don't have a system in place. You don't, on their straw, you didn't have a system in place. And that's not a good excuse here. In my submission, estates acquisition applies in the unlikely event, indeed beyond reasonable doubt, non-event that they didn't know. So much for no good reason to attend. The third ground as to merits, there the judge recorded it, and there's a supplemental bundle that's in 114 paragraph 37. Sorry, that's the judgment. Many defence points have not been relied upon. He dismissed the impossibility claim and said it should have been a matter of asking for an extension of time. He said the breaches hadn't been cured. He dismissed the argument that it could be a defence that the disclosure of company assets was illegal in the UAE, which only applied to the company assets anyway. And in any event, it wasn't a defence because it would only be a ground for variation. He also, the question about the expert and Mr. Zari's independence, he found that was irrelevant to that question, and so it is. I mean, suppose that they did get evidence that showed it was illegal in the UAE to answer these questions, it still wouldn't be a defence. You have to come along to court and ask to be excused here, and they didn't. So, that, in my submission, these judgments of Mrs. Justice Butcher being impeccable, based upon the evidence, inferences which he was well entitled to make, and which I would submit the right anyway, and no errors of law being identified there. So where did the judge go wrong? Now, the main thing that my friends have come up with, of course, is this point about service. If one was simply talking about the application to set aside under CPR 35, they would really have no arguable grounds of complaint at all. But we say that if there is going to be permission to take this new point, given the fact it was actually conceded below, because one of friend's predecessors actually said that service was permitted the way it was, assuming that that permission is given, I'll address that. So, the contention is not that a committal notice must be personally served and can't be served by alternative means, even though such means might be mentioned in the main action. That we don't take issue with. That is quite important to make that clear. We can see that as a matter of policy. If you have an ordinary action in the High Court where documents can be served by ordinary means but also by alternative means, that ordinarily, one can't have a hard and fast rule, but that it might be a bit of a stretch to say that alternative service by something which is not by email or by text might not stretch to the actual full-blown committal application, which starts anew and much more sinister nature of proceedings, none which might end in imprisonment, and that the CPR 81 does have a code for personal service. So at that point, I'm not going to argue against that. That seems to be fair. But that's not what our case is. In this case, the committal proceedings were launched and known about in the proper way, proper service done, with these defendants knowing that that was on foot against them. This is the proposition which is now being advanced now is a much more limited one, which is that a notice, a letter saying that there's been a change of date must be personally served. That's not something which arises from the rule at all.
That's not quite the submission against you. It's that it must either be personally served or the court must consider afresh whether an order for alternative service should be made, and if so, what order.
Yes, I suppose that is precisely what is said. Now, my response to that, I'll take your report to the authorities in a second, is that doesn't quite come out of the authorities. It doesn't come from the rule in CPR 81, which only is to do with the service of the notice of motion. So they rely upon Chilton, which is in tab 1. And Chilton was the case where there was a notice of motion that was served. This was a case, though, where there was no anterior, previous direction for alternative service of any sort. That was completely out of the picture. There was no question that there was any alternative service existing in those proceedings, unlike these ones. There, in that case, there was no postbox, and the defendant complained that there might have been some papers in the mud around his rural residence. No postbox. So although the judge thought it probable that she was lying about it, he couldn't really be sure. That was a case where, in fact, there was a risk that he didn't know what was going on. That's a distinction, in fact. But this first distinction, that there was no possibility of alternative service, that wasn't before the court there. So those are two distinctions. Now, the Court of Appeal in that case, in Chilton, they said they were bound by Alden's case. More on Alden's case in just a few minutes. But I think I just said, though, that we accept the part of the decision of Mrs. Justice Cockerell in Erdenet that ordinarily you would need to get a special alternative service order for a committal notice.
You accept that?
For a committal notice, yes. Not necessarily, though, for a letter changing a date. And all that Erdenet Mining is authority for is that you need to have a specific alternative service order for starting the committal proceedings by serving the committal proceedings themselves. That's all it's authority for, not for subsequent orders for directions like evidence or hearing. That's all it's authority for. But so I have as primary submission that here, because we had alternative service in the proceedings generally, which did say for any documents served in these proceedings.
Yes, but those proceedings and the alternative service orders were made, first of all, by Mrs. Justice Cockrell and thereafter by Mr. Justice Calver.
Yes.
Both of those preceded the issue of the committal
perfectly true.
notice.
So the case against me is that the committal proceedings count as a completely fresh sort of
Yeah.
proceedings. You need to have a set of orders in that.
Yeah.
The contrary submission, which I'd make as my first submission, it's not my only one, but the first one, is that since these committal proceedings are actually in these proceedings, it's not by a separate application notice in separate committal proceedings, which are independent, but it is in these very same proceedings. It means as a matter of construction, alternative service can apply to any document, but not, I concede, I think I should with Cockrell judgment, not the actual notice of motion launching them. But thereafter, if the parties know and defendants know that there is a pre-existing email or text, which is a source the court has said that you can be served on, then once you know the committal proceedings are on foot in the same action, then my first submission is that that order, its true construction, does then bite on something like a change of venue or date.
But
That's,
if you accept the point that a committal notice does require personal service,
yes,
and would I be right in thinking that underpinning that is the nature of committal proceedings, fundamentally the liberty of the subject?
yes.
Right. That being so, how can you then say in respect of a notice giving you a specific listing date when the liberty of the subject is going to be scrutinised and possibly adjudicated upon? How can you say in those circumstances there is such a difference that you don't need personal service or at least an application for alternative service?
Well, it's there's a difference in the sense you've got to know, like you do with an ordinary action, that the actual originating proceedings are against you, that the committal's there out against you. But then if you also know in those proceedings there's an alternative route which exists, then it's fair enough then to use that alternative route for the supplemental directions. In a sense, the decision as to whether that route is a way in which matters can be brought to the defendant's attention has already been adjudicated upon by a judge. He's already found that to be the case. And so that means that having further documents served under that means is a reasonable thing to do without having to redo it. Unless there's been some change of circumstance to show that this email or that telephone number are no longer in use. That's my first submission, but I have another one which I think trumps it, which is the way that Alden, which was applied by the Court of Appeal, what happened to that in the Frame case. More recent court of decision of this court, it's this. In Alden's case, Lord Justice McGaw said that the rule about personal service of the change of hearing admitted of exceptions where there were exceptional circumstances. It wasn't a hard and fast rule. And in Frame's case, Frame considered themselves bound by Alden. But the critical thing was this exception. And that's really what I'm relying on here. It's logically a secondary submission, but really it's my submission, probably the most important one that's applicable. In that case, in Frame's case, the contemner had been ordered to deliver up his passport. In breach of his passport order, he didn't do that.
Where is it? Can I just...
Sorry, yes, okay.
No.
I thought I'd describe it first. That's it's tab 3.
3, yep, got it.
If one takes a look there at pages page 21. And it's really starting at the top of page 22, actually, I think, is where, sorry, a quotation from Lord Justice McGaw in the Alden case, where Lord Justice McGaw said, "I've no doubt Mr. Slowe is right in saying that although the sub-rule does not expressly refer to notice in respect of an adjourned application, such as this was, for committal being served on a respondent person, it must by application be so construed. At any rate, unless possibly there might be some very exceptional circumstances which would render it inapplicable.
I'm sorry, where are you reading that from?
So it's the top of page 22 in tab 3 of
22.
the authorities bundle.
Thank you.
So Alden's case, this is a quotation from Alden's case, which was applied in the case relied upon by my learned friends, which is Chilton's case, which is the first one in the bundle, saying that ordinarily you get personal service of a change of hearing. But what this court in Frame concentrated on was that Lord Justice McGaw had said that there might be some very exceptional circumstances which would make that rule inapplicable. He found there were no such in that case. But in Frame's case, they did, because in the present case, Mr. Hideous admits there was no personal service, no dispensing. Let me just say what the background was. The contemnor had been told to give up his passport. He hadn't, and there was a date fixed for the committal hearing against him. He knew about that date. He didn't turn up, though, because he fled the country. So that means he wasn't around to know when the next date was. And that was held to be an exceptional reason why he couldn't complain about not being personally served with it. And so, if one then takes the, once one sees that in the second paragraph, halfway down the second paragraph, it says, we have a man represented in court on 20th November by Solis and Counsel. The nature of the case is there was an order to surrender his passport, not leave the country. I'll put it neutrally, but there's a written exec regular in force. He's in breach of that because he didn't surrender his passport, no explanation given. It was adjourned until Monday 23rd, but he disappeared. The judge was told he'd gone. In those circumstances, it seems to me this is an entirely different case from what the court was considering in Oldham's. It seems to me this is the sort of exceptional case which Lord Justice Mulgore almost certainly did not have in mind, but properly made allowance for. This was not an adjournment to the case at the behest of anyone. It was really a continuation of the case with the judge ordering a bench warrant, where it was reported to him about the fleeing to the country. So not so much as an adjourned hearing in the same sense, it was a continuation. He was entitled without further service to pass sentence. If I'm wrong about that, I didn't go into this in length. I was told that this court has the power under section 13.3 of the Administrative Justice Act 1960 to put right what's gone wrong. There's no merit in the applicant's case, hasn't been prejudiced by failure to notice, and I use my powers to dispense with service of any notice if necessary. So it's if one looks over at page 24 and sees what Lord Justice Bingham says, second paragraph up from the bottom,
It's
he
the
says
first
it's quite
sentence,
different.
isn't it?
So sorry, my lady.
It's the first sentence in that penultimate paragraph.
Those facts in my motion show quite clearly the hearing on the 7th of December was not a revival of the notice of motion or an adjournment to a date to be fixed, used by the Master of the Rolls, but something quite different. The giving of an indulgence to the defendant to give him an opportunity to make representations. History records how he responded. It's equally plain in my judgment that in Alden's case, Lord Justice McGaw acknowledged the possibility exceptional circumstances might render the rule inapplicable. In my judgment, those observations in point here. These exceptional facts, there was in my judgment no irregularity or flaw. Then he goes on to say that he also would, if necessary, use section 13.3 to dispense with the need for personal service. Now, so my submission on the basis of Frame's case is that personal service, the rule about personal service in common law, need not be applied by the courts if there's exceptional circumstances.
Very exceptional.
Very exceptional circumstances. And in my submission, that's the position that we find ourselves here. We find ourselves in a position here where we've got appellants before the court who remain continuing contempt of court, who have failed to give disclosure now for over 2 years of the matters that they were ordered to do so, who have evaded committal proceedings by asking for 6 adjournments and then never putting any evidence, either exculpatory or seeking to purge. To this very day before this court, there's still no apology, there's still no promise to purge. That, thank goodness, is very exceptional in these courts. disengaging proceedings without putting in a system, without giving an address in breach of the rules of service, non-participated on the evidence as found by the learned judge, knew full well this hearing was happening on the 4th of October, told the most extraordinary lies, quite extraordinary lies, in the sense of denying knowledge of a committal process which they'd known about for 8 months and had solicitors dealing with, quite extraordinary, in order to try and obey the consequences of not turning up. So this is a case where if the ordinary rule might be to try and effect personal service or to get an order for alternative service before, in this case it would be alternative service, probably of the same sort we already had, which is the one that Mrs. Justice Cock and Mr. Justice Carver put into place. On that then truly becomes a meritless technicality, and these are very exceptional. My submission would be denial of justice to allow that plea in the light of the fact, as my Lord Justice Males has pointed out more than once, a distinction between service and knowledge, where they knew what was going on and lied outrageously trying to get out. This is such a case. Those circumstances in my submission means are in that sense.
Is this point going to the merits of the point? That is to say that even if the rules are to be interpreted as generally requiring fresh consideration of alternative service for contempt proceedings, that is not so in exceptional or very exceptional circumstances? Or is it a point going to whether that issue should be allowed to be taken in this court when it wasn't taken below?
Oh, I see what Lordship
or both.
Certainly the first, because the first would be a point that one would take in front of a High Court judge of first instance. I think it certainly goes to that. The second point about whether it should go to whether the point should be raised. First of all, I'm going to answer that, but first of all, I do recognise, and certainly the bank recognises, the extreme seriousness of committal hearings and recognises the fact that the court has to be utterly scrupulous in ensuring that there's fairness of procedure and that defendants are given every opportunity for defences. That goes without saying. Having said that, and therefore leaving it to your ladyship in the court to decide whether this new point should be allowed or not, make this observation. It does go to the second point because if the point had been taken below, and not in any way suggesting Mr. Yates was to blame for not taking it, but I mean, if it had been taken below, then I would have had the opportunity then to have applied for retrospective alternative service, or whatever one wants to call it, or dispensing personal service, in the way that happened in Frame's case, and also actually happened in Erdonet, actually, because Mrs. Justice Cockrell, having found that you need to have personal service of committal proceedings, then went on to actually dispense with that need in her judgment, because the circumstances showed that in that case the defendant knew full well what was happening. So I could have made that application below, and in the light of what the learned judge found about what they knew, it seems almost inevitable he would have acceded to that application and said, look, the alternative service is perfectly good because they found out that way. And so, if necessary, I'll make that technical order to retrospectively validate the service by that means. So yes, I suppose to that extent I have been prejudiced. I could have made that application to the judge. So the point shouldn't be allowed. Alternatively, I'd ask this court to make that, to go the same way the Court of Appeal did in Frame. Maybe that's not quite an answer to Roger's question.
No, I think it is.
So that's my third point, is that should be the course this court can take as well, as Mr. Justice Butcher.
Sorry, the third point is we should do what?
If Mr. Justice Butcher, I say, would have retrospectively dispensed with the technical need for personal service, having found that they knew full well what was going on. And therefore, if such an order is required from this court, I'd suggest it's open to this court to have the same dispensation in the light of Mr. Justice Butcher's factual findings, if it's thought necessary. So some distinctions, milady. 3 cases were cited by my learned friends. There was Beeston at tab 2, and there was Westrop at tab 20, and there was also MDR and Mayer. I'm sorry, I haven't got the tab number. All of those cases are distinguishable because although the issue there was service of an injunction, it wasn't service of notice of the time of a hearing. There were orders under CPR 71, at least 2 of them were, saying, here's an order saying you must turn up at court on this date or it's a contempt and you will be sent to prison for it. So these were not really notification of hearings, cases like this one. That was about service of an injunction to do something, which happened to involve turning up at court. So obviously when you say personal service for that, that's an injunction. So they're distinguishable. Nelson and Clear Springs is distinguishable, which was the case where CPR 39 didn't apply, because that was a case where there hadn't been service of the originating proceedings at all. And that, of course, is quite different. If you don't actually serve your claim form on someone, then enter a judgment against them, then they're entitled to have the judgment set aside, forgotten what the expression was, but de bene something, meaning as of right.
So justitiae.
Thank you. Lady, thank you. As of right. So that doesn't apply. And some defences they raise, I think I've dealt with them, but the defence that they believed on legal advice, they didn't have to obey the orders on foreign legal advice. They say it didn't amount to contempt. That's wrong in law, and the authority for that is Masri and Khoury, tab 9. I'll just give the references. It's page 145 to 146, applying Lord Wilberforce's ruling on that. This is well-established law that if someone knows about an order and they intentionally do an act which is inconsistent with that order, that's a contempt. Even if you don't have to prove that they believed it was a contempt or knew it was a contempt. Lack of intention goes to mitigation, but not to liability. That doesn't work. The defence that if you only have to disclose assets worth more than £50,000, that you can value them having deducted it's the unencumbered value attached. That's wrong, with the Court of Appeal held in the ADM and Grainhouse case. There is market value that counts for a disclosure of assets under a freezing order and not unencumbered value, and that the reference there is tab 22, page 467.
But in any event, the orders dealt specifically with assets that were attached.
Lady,
It
that is
made
true.
specific provision about those, so
Don't need this, no.
don't need that anyway.
True, Lady, you're right, it's belt and braces.
The Masri case, I know, came to this court several times, and even the Supreme Court once. We've got the judgment of Mr. Justice Christopher Clark. Was this judgment appealed? And if so, was anything said at a higher level on the points which we've been referred to?
I'll check.
Yeah, okay.
We'll check and we'll, if we don't find the answer in the course of the next half an hour, then we'll send a note. If either way, we'll send a note. Then the defence, I've already mentioned, the idea that if this court orders someone to do something, disclose something in England, that might breach a foreign law. It doesn't invalidate the order, it only gives grounds for variation. So it's not an excuse for non-compliance, and the authority there is Serviu Laboratories, which is at tab 11, page 27, paragraph 92, and also page 279 at paragraph 99. There was some point made that the judge didn't direct his mind to actual knowledge as opposed to just service, but that's wrong, because he clearly did. But also, in fact, the order that he made on the setting aside, he actually said in the recital that found that they were aware of the date of the hearing. So I think that's it. Sorry, forgive me. Yes, it's the core bundle at tab 7 at page 2. If one looks at the recitals there, it's an ultimate recital upon the court being satisfied that they've been served with the documents and that they were aware of the hearing. So no judge actually made a finding that way, so the ground of appeal saying he didn't think about that isn't right. So, Lord and Lady,
And there's a distinction between service, which relates to 3 things, and then awareness about the date of the hearing.
Lady,
in
yes,
that recital.
I haven't twigged to that, but yes.
Yeah.
So where then does that leave their grounds of appeal? If one takes a look at tab 3 of the core bundle, this First Defendant's grounds is slightly more prolix than the second. Point 1, that's a finding of fact, which I would endeavour to show that the learned judge set out the reasons why he found that fact as a judge of first instance, and that can't be interfered with. He had evidence of which to base it. There's been no identification of any error of principle or failing to take into account anything relevant. So amply supported by the evidence. 2, the court was wrong to find that service to the firm constitutes good service and or knowledge. The knowledge of the hearing, that really goes again with number 1. He was entitled to make that finding as a matter of fact. He did. As regards good service, you have my submissions about why it is that frame should apply to this case and why it is that this is a very exceptional case and that's why service should be good. Alternatively, on that ground, that the learned judge, had he been aware of the challenge, would have retrospectively validated it. And invite this court to do so, or to knock out that ground of appeal for that reason. 3 doesn't apply, I'm not relying on that phone. 4, the judge knew full well that they weren't represented in abroad. Of course, that was all part of it, so there's no question that he didn't know about that. The entire proceedings were based on that. 5, wrongly allied service and actual knowledge. Well, I think we just demonstrated he hadn't, because of the point that my Lady Justice Laing just made. 6, the wrong inference there. That's an inference he was entitled to draw, given the fact that there was a no-show at the other things and a withdrawal from the proceedings generally. 7, too much weight about the showing a residential address must have showed information. Well, I mean, it isn't just a residential address, it's also the fact that the one keeps swearing affidavits for the other. And in fact, Majid holds the power of attorney for the other. And also that they had a common telephone number, which they gave in the Sharjah proceedings. So he gave appropriate weight to that. 8 is the point about having a defence based upon believing you're not breaching an order. That's bad in law. 9, all the stuff about the expert in 9A and 9B, my submission is irrelevant because it doesn't matter whether or not it's illegal by you're breaking the law abroad if you disclose here, because that doesn't go to invalidate an order. And 10, simply a kind of a roundup. I think I demonstrated that no judge couldn't be faulted in the way he went through the 3 headings. And 11, in light of the fact the judge found they knew full well the hearing was happening, Article 6 isn't breached. That pretty much, I don't think I need to go through this other grounds of appeal because I think there's nothing, don't think there's anything additional there. So in my submission for those reasons, the appeal should be dismissed. Unless I can assist further.
Thank you very much indeed, Mr. Peter. Mr. Trotter.
Thank you, my lady. Can I start with an apology that my main contribution to this appeal so far has been some incessant and rather irritating coughing, no doubt from the back row. I'll endeavour to improve on that.
Mr. Trotter, it's very good to see junior counsel following.
Thank you, my lady. Secondly, my Lord Justice Mayles asked about Mr. Justice Christopher Clark's decision in Masri.
Oh, yes.
In the limited time available, what I've been able to ascertain is that it was appealed, but not on that point. And at least the decisions in Stancombe and Itelli were not considered in the appeal judgment. That's as far as I've been able to get, but we'll certainly verify
All right,
that.
thank you.
So, my lady, I'll deal briefly with the sanction grounds. My lady, by the time we get to this point, the court will have upheld the judge's findings that the Al-Saris failed almost entirely to comply with their asset disclosure obligations, that they knew about the hearing at which that was being tried and decided not to attend, and that they then re-engaged at the last minute, 3 working days before the adjourned sentencing hearing, and sought a further adjournment only to adduce what the judge found to be false evidence for their reasons for not attending in the first place. So my learned friends were entirely realistic when they conceded that this is indeed a bad case on any view. And my lady, in my submission, the grounds of appeal pick around the edges at the reasons why the contempt is very serious and aggravated. But many of the reasons that the judge found that it was serious and aggravated are not the subject of any independent challenge once one gets to the sentencing appeal. My lady, I don't detect any great difference between us in the law, but can I just take the court to one authority?
Yes, but there doesn't seem to be a great difference in the law between the two.
Yes, my lady, I'll do so very briefly. It's the one that we've handed up separately. The facts of the case are not important, so we can go straight to the principles which are summarised at paragraph 37 on page 8 of the document. These, I'm sure, will all be familiar, so I'll take them quickly. First point is that the court will be reluctant to interfere, of course, with the sentencing decision. Then over the page, we have a discussion of the principles in sentencing for contempt. At 40, Lord Justice Jackson, the Court of Appeal says, breach of a court order is always serious because it undermines the administration of justice. And the point I particularly want to draw attention to is further down in that paragraph, where the court says, Mr. Underwood was correct to submit that the decision as to the length of sentence appropriate in a particular case must take into account the maximum sentence. But because the maximum term is relatively short, we do not think that the maximum term can be reserved for the very worst sort of contempt which can be imagined. Rather, there will be a comparatively broad range of conduct which can fairly be regarded as falling within the most serious category and therefore justifying a sentence at or at least near the maximum. That's the only point I wish to highlight out of that. So, my lady's been taken to the judgment already a number of times, I won't do that, but it may be useful to note that, as I said, several of the points made by His Lordship are not the subject of any independent challenge, and in very brief summary, they are at paragraph 5 of the sanction judgment. He refers to the fact that the contempt was serious, incorporating the reasons given in the 4th of October judgment. That 4th of October judgment is found at Core Bundle 8, at page 89. We probably don't need to turn it up.
No, we don't.
And Mr. Peter has already canvassed the background in some detail, so I don't need to do that again. But there is perhaps one part of the chronology that I'd just like to emphasise to make sure that the court has the chronology, and that is the the rather extraordinary event that happened with the Sharjah proceedings, where they were served with the freezing order, said that they were going, on the 14th of April, wrote saying that they finally did have instructions that their clients wished to comply. They said they'd do so by the 28th of April. My lady, the Sharjah proceedings were then launched on the 25th of April, which was 3 days before that self-imposed deadline. And then it was 2 days after that, on the 27th of April, that we had the witness statement in support of the jurisdiction challenge, which reiterated the correspondence indicating that the compliance would be forthcoming the following day. Now, my lady, what that indicates, most probably, is that the solicitors were not told that this was going on in Sharjah. And in fact, while they were telling their solicitors, and the solicitors were telling us, that they were going to comply with their asset disclosure obligations the following day, they were in fact pursuing proceedings in Sharjah in order to avoid precisely that obligation. My lady, it in fact gets worse than that, because of course that action is then dismissed by the Sharjah court, and they go on to file Majid 2 on the 13th of May. But even then, at the time Majid 2 is filed, there is in fact an ongoing appeal in Sharjah against the order dismissing their attempt to avoid compliance. And that is not mentioned anywhere in Majid 2, despite the fact that there's an apology in Majid 2 for not complying with the orders of the court. So even at that stage, they're trying to ride both horses. My lady, turning to the grounds of appeal in relation to sentence, there are 3 of them. They were taken fairly briefly by my learned friends, but I ought to deal with them one by one anyway. Ground 12.
The point that was really taken, as I understood it, both by Ms. Pugh and Mr. Lemon, is one of what might be called parity, but it was distinguishing the sentence imposed upon the third defendant, who hadn't taken any part in any proceedings whatsoever, and the sentence imposed on the first and second.
Yes, my lady. The short answer to that is that the mode of engagement of Abdullah and Majid al-Sari is indeed worse than nothing in this particular case. And can I divide that into 2 propositions? First, that on the asset disclosure side, no useful asset disclosure has been given at all. It's been suggested in passing that some assets were disclosed and that therefore puts them in a better position than the third defendant. In fact, when one looks at the affidavit, and I can take your ladyship to it, nothing new is forthcoming. So perhaps we should turn that up. It's at Supplemental Bundle, tab 11, page 120. So this is midway through Majid 2, because the first 8 pages deal with reasons why disclosure is not going to be given. And then we see there's a subheading above paragraph 30, and this is where the purported asset disclosure starts. We see in paragraph 30, First Defendant doesn't have any assets in the UK. Paragraph 31, there's an express refusal to give disclosure of any assets in the UAE. Paragraph 32, there's a denial that he in fact has any interest in these companies. No asset disclosure there. Paragraph 33, again, the manager of these companies, but not giving any details about them or their assets. The closest one gets to any assets as regards Abdullah al-Sari is a paragraph 34. It says, as to assets already the subject of attachment in the UAE, a list of attachment / execution cases is exhibited. And lady, I'm afraid that amongst the excessive reams of papers that your ladyship's been burdened with, that is not in the bundle. But I can tell my lady that it doesn't contain any assets. What it contains is a list, as it says, of judgments against the defendants. And although that is not in the bundle, Mr. Richards says so, if it's useful, at page 226 of the bundle. In tab 66, sorry, paragraph 66 of his fourth affidavit, where he describes it as a list of 25 outstanding judgments, giving a total outstanding sum of the amount against them. But it doesn't specifically identify any assets, which are the subject of attachment at all. It's just a list of the debts that they owe. So that's Abdullah. Then Majid al-Sari is dealt with from paragraph 36 onwards. And here we have paragraph 36, the vehicles. These are the vehicles, of course, that are listed in the freezing order. So the claimants already knew about them since 2014. They had been the subject of the freezing order granted by Mr. Justice Cockerell, so that's not new information. Paragraph 37, again, an express refusal to give disclosure of any assets in the UAE. Paragraph 38, I'm the manager of various companies, which he doesn't say he has any ownership interest in. Paragraph 39, we have some bank accounts, but again, the last line of that paragraph, both accounts have been subject to consecutive freezing orders issued by the English court since 2014. And my lady will have picked up that 2014 was when the Section 25 freezing order was obtained by the bank. So that's not new information. Those are the same accounts of which the claimants were already aware. And then paragraph 40, the Al-Sari home compound at which he's been served. And he says in terms, the first claimant is already aware of this property. And finally, paragraph 41, he says the list of attached assets referred to at paragraph 155 of Richards 1 appears to be correct insofar as it relates to me. My lady, that list is a list that was produced in 2014 by the claimants. And he says it appears to be correct. There's no definitive confirmation. There's no confirmation in relation to Abdullah that it's correct. And indeed, it would be very surprising if it was still accurate, given that it was by that stage 8 years old. So, my lady, in my submission, the point that something good has come from their involvement in these proceedings goes nowhere. In fact, and I won't traverse all of the procedural background, but a great deal of cost and inconvenience and waste of court time.
So that's what you mean when you say it's been worse than nothing.
Precisely. Yes, my lady.
Thank you.
I suppose the other response to a disparity argument which might be given, which is given from time to time in judgments of the criminal division of this court, is that just because one defendant gets lucky doesn't mean that the other defendants haven't had an appropriate sentence passed on them.
That is the principled response, and I would gratefully adopt it. My lady, there are various other matters which are raised in the skeleton which haven't really been pressed orally. One of them is the apologies. My lady's already been taken to them to some degree. The short point is that they're not genuine apologies. They weren't accompanied by any compliance. They were usually, in fact, I think in each case, accompanied by either criticism of the court or an observation that they weren't going to comply. And in at least the first two cases, were in parallel to attempts to not comply in the Sharjah proceedings. I can take the court through those, but I anticipate that patience may be wearing thin at this time of the
Not
day.
patience, just keep your eye on the clock, that's all.
Yes, my lady. That's the apologies. There were a handful of other new points raised in the skeleton which are not in the grounds, which I can just deal with very briefly. Majid says that the fact that the judge took into account his failure to attend the jurisdiction challenge and evasion of service in the sentencing amounts to double penalisation. My submission, it doesn't. It's purely taking into account the context against which the non-compliance has to be assessed. And then the first defendant, Abdullah Al-Sari, relies for the first time, I think, on his age as a mitigating factor. My lady, that wasn't relied on below, but in any case is not on its own a mitigating factor. There is an authority which I won't take the court to, but it's the Deutsche Bank case at first instance, which was at tab 18, page 372 at paragraph 40, where the court effectively says the prisons are perfectly well equipped to deal with contemnors of an advanced age. The question is, are there ill health issues? And my lady, the court may have picked up that actually there was a point where Abdullah Al-Sari did say that he had ill health issues that should be not taken into account in mitigation at that point, but were a reason why he couldn't attend personally the adjourned sentencing hearing. Now, that was swiftly abandoned when it transpired that his own solicitors in correspondence, only months earlier, had said that he needed 14 days to apply for a visa in order to come to the United Kingdom to collect some confidential documents. I can give my lady the reference to that.
What is his advanced age?
78, I understood this morning. In the appellant's notice it says 77, but no doubt he's had a birthday since then. The reference to the letter is S35 590, and it's dealt with in Mr. Richards' 13th witness statement at S34 463, paragraph 34. I don't think we need to turn it up.
Do you mind mentioning the point that we invited them for cross-examination? I forgot to do that. This is related.
Oh, yes.
I forgot
And
to say that.
my lady, there was a point taken in oral argument this morning that it was unfair that Majid 3 was found to be dishonest in circumstances where he wasn't cross-examined on that statement. My lady, the answer to that is that the claimants in fact asked Majid and Abdullah Al-Sari to attend the adjourned sentencing hearing. I give two references for that. The first is the skeleton argument that went in just before the first adjourned sentencing hearing, that is before the 27th of October hearing. At paragraph 8 of that skeleton argument, which is at S30 418, we noted that our solicitors had asked in correspondence that they give an undertaking to attend, but that no response had at that stage been received. Then the 27th of October hearing happened. There's no transcript, unfortunately, of that hearing. But in Mr. Richards' 13th witness statement, which came after that hearing and before the second adjourned hearing on the 20th of November, at paragraph 34, he refers to the fact that Abdullah said that he was too ill personally to attend on that occasion as the reason why he was not taking up the claimant's invitation. So the short point is there was ample opportunity.
Abdullah, what about Majid? Because he's the one who'd given the witness statement.
Yes. So Majid, in Majid 3, did in fact say that he was too ill to attend. So sorry, I'm muddling this chronology a little bit. Abdullah said that he was too ill to attend on the first adjourned hearing. Then when we got Majid 3 between the two adjourned hearings, the idea that Abdullah was too sick to attend had fallen away. At that point no longer appeared. Instead, it was now said that Majid was too ill to attend. And we had from Majid a medical report.
Is that the back problem medical
Yes.
report? Yes,
Yes.
I've read it.
But the medical report also
saying he
said
should go to Germany.
he'd like to go to Germany. Yes, my lord has the point. Yes. And so both of those points have evaporated. I don't think they were pressed at the second adjourned hearing, and certainly the Majid point hasn't been pressed on appeal. So, my lady, there's nothing in that. That's all I have to say unless someone can assist.
No, thanks.
Thank you very much, Mr. Trotter.
just me, my lady, if I may briefly, bearing in mind the time. Do
Well, can I just ask this? I'm just concerned, in fairness, Mr. Leonard, you told the court that you would be dealing with the reply, but is there anything Ms. Pugh wants to say on sanction? Because Mr. Trotter has just given a bit more detail. Is there anything more you want to say by way of reply? I'm not inviting you to do it, I'm just saying it's there.
No, there's nothing further from me. I've said all I want in my skeleton.
All right, thanks very much indeed.
Yes.
Thanks, Mr. Leonard.
May I just join with my learned friend, Mr. Peto, on the issue of frame and this existing or otherwise discretion and circumstances in which it might do so. Before I leave that, though, as I've got it open, forgive me, I will take it now, and that is this idea of a retrospective order being now applied for in this court should the application in other respects succeed. We are just constrained to observe that it's in your bundle at 5:30. There are various caveats to provision of methods of service by way of alternative when an individual is out of the United Kingdom, as would be applying here. And I have to say, for my own part, I'm not sure I've seen the evidence that would support such an application at this stage, but it may be my own friend can help me and we can put in a note either way if that would be of assistance after today. Second point, Aurelian Masri was considered in a case in this court, not this courtroom, called Turk and Ispelin, judgment handed down yesterday, and we will provide it to you as soon as we can. My own friend Ms. Pugh was in that case, and that's why she knows. And we don't believe it was otherwise appealed. It was followed, in fact, I'm told, yesterday. So we'll provide that as soon as we can. One further point, I say this because I think it should be on the record. Lord Justice Myers, you raised an issue about your previously acting for Fanoil.
Was it 4? I couldn't remember.
You
I
actually
can't
acted
remember.
for a company called Patronus, I
Did I?
think, against Fanoil.
Okay.
I looked at the judgment. I'm happily to provide it. There is literally no reason why that should have any impact on these proceedings at all, but I wanted to say that in open court, just in case that was why you were asking us to concern.
Well, I'm very grateful. I think, yes, now you've mentioned, I think it's a shipping case to do with a ship-to-ship transfer of some oil, something
It
like
was
that.
boats, yes,
Was
indeed,
it?
my lord,
Yes.
yes. And more than that, I haven't
Okay.
really read on it, so I'm stopped after paragraph 20.
No, I think that was a very good place to stop.
Indeed. I think you lost, but anyway, moving on.
You got that far.
It's in the first paragraph, I think. But let's just look at frame there, because it is an interesting case, not least because, as Lord Justice Bingham, or Lord Bingham, said in his own judgment, and this is your tab 3, page 16. It's as though the previous case relied on by my learned friend has foreshadowed the possibility of an exceptional circumstance existing, and that frame is that sort of circumstance. And I just invite you to Lord Justice Bingham, on page 23 of the bundle, internal pagination 8, second paragraph, where he says the facts of this case are happily very unusual, and it is on the exceptional character of those facts that, in my judgment, this appeal turns. I'd invite you to read the facts of the case, but the contender was actually a solicitor of the Supreme Court, a partner in a city law firm who was supposed to attend before Mr. Justice Vinelot on a given Friday for cross-examination, turned up, apparently had an affidavit ready to be filed, left the court, having been told to deliver up his passport, was due back on Monday, and then didn't turn up. And one can start to see just how that sort of scenario might indeed be factually within the grasp of a very exceptional case. This, we would submit, is a light years away from this. And it's not exceptional circumstances as per frame because the contenders are exceptionally bad in the way they behaved in the background, which is the way I perceive my friend to take the point. It would need to be exceptional in relation to the way in which the mechanics of service have actually played out. I hope I can use that vernacular. And here, I observe in passing again that this is a date brought forward rather than put back. And although it may be slightly counterintuitive, that, in my submission, may make a difference and may make, therefore, the need to ensure proper communication by an ergonomic mining approach to that relisting has been carried out. Plain it is that Chiltern and Keene was different precisely on the mechanism that was being considered in terms of service, and my learned friend seeks to distinguish it. But all you need to do, in my respectful submission, is look at the head note, which is on page 4 of your authorities bundle, a little paragraph 2, where the later paragraphs are summarised in this way. The reason for requiring personal service of the notice applied equally to notification of the new hearing date, where there had been an adjournment to a date to be fixed or a revival of the notice motion, and accordingly the defendant should have been personally served with a notice of the hearing, and obviously, or not if it had been dispensed with. And we say there's a direct parallel here. My own friend seeks to suggest in a way that service of the claim form, suggesting he's going to try, or his client's going to try and put people in prison is one thing, but telling them if the date has changed and somehow is slightly less important. And with great respect, I don't follow that reasoning. They are both equally important because this process carries with it such potentially punitive consequence. I think my own friend also, it may have been a slip in forensic excitement, as it were, said that we don't complain about the legal nature of the service or not. We do, and we say it should have flowed from an alteration as per an application pursuant to the thinking in the Erdnet mining case, and it didn't happen. Is there anything else I can assist the court with?
No, thank you very much indeed. Well, the court, may I say, is grateful to all counsel in this case, and no doubt those who have been working with them for the contributions they've made. You'll be surprised to hear that judgment is going to be reserved, and when the judgment or judgments have been drafted, they'll be sent to the parties on the usual terms. I'm sure I don't have to remind anyone in this court about the terms of the Council General of Wales Act, which dealt with the issue of contempt as well. And that will be it. Please, no re-arguing, simply correction of any typos or any factual, and I mean very narrowly factual mistakes. And I'm grateful for the indication that there may be additional documents that will come in. Thank you all very much indeed, and for the assistance you've given.